Welcome to Ring of Fire. I'm Farron Cousins, sitting in for Mike Papantonio. Today on Ring of Fire, we'll find out what to expect from the Supreme Court in their new term, and which of your rights might be destroyed by this corporate court. We'll also take a look at Eric Holder's legacy, and we'll try to find out why he never went after the Wall Street bankers. And we'll tell you how the Obama administration is working to make sure patients know if their doctor is on Big Pharma's payroll. We have all that and more coming up, but right now, you've stepped into the Ring of Fire.
You can't change Washington from the inside. You can only change it from the outside.
Grand jury secrecy rules.
For political gain.
The press can find out.
That has nothing to do with politics, but go ahead.
It wouldn't bother me.
Oops.
The U.S. Supreme Court recently began a new term, and as their very first order of business, they decided to issue a ruling that severely cut back early voting in the state of Ohio. The court's previous term had given us decisions that gutted the Voting Rights Act, forced religious views on everyone, and gave corporations even more influence over our elections. The next term could deliver some equally damning opinions, and I'm joined now by David Haynes to tell us what we can expect from our corporate court. So David, the Supreme Court back in session, first thing they do early Monday morning when they came back was say, you know what, Ohio, we're going to restrict early voting. They didn't specifically say for minorities, but we all know that that's what the real target is. Mike Papantonio and Sam Cedar are going to be discussing this a little bit later in the show, but I wanted to get your take on that very first ruling that came out of the court's new term.
Yeah, it's just, of course, I think 16 hours before voting was to begin, early voting was to begin in Ohio, and a very unfortunate decision coming down from the U.S. Supreme Court, reversing the appellate decision and the trial court's decision, and that is basically eliminating these early voting periods, which, as you said, is going to have a very disparate impact, particularly on racial minorities, on African Americans, but also young people, Latinos, students, as well as seniors. And you know, it's a question that we've talked about before in this program. It's a fundamental question is, do we want more people to vote or not? And of course, the Republicans don't. They want to restrict those who come out to the polls, and the Supremes are backing them up.
Right, and this is supposed to be a participatory democracy. I mean, that is essentially the foundation on which American democracy is that it's participatory. And Republicans, especially those on this corporate-controlled Supreme Court, want to go out there and say, you know what, minorities, students, elderly, those of you who may need a little bit more time to get to the polls, especially in a crucial swing state like Ohio, we're taking away your fundamental right. We're taking away basically what makes America, America. And that is so disappointing, but it's predictable. I mean, we could have called that 6 months ago with this court, couldn't we?
Yeah, it's true, given the court's history, and it's very unfortunate. As you say, Ohio is a huge battleground. We've seen out the rollout of basically, roll back, we should say, of a lot of the voting rights in a number of states, North Carolina, Texas, other states, and Ohio is a very crucial state. And so this was a very important decision, a very unfortunate one. I mean, what is the downside to early voting? Of course, the theoretical argument on their side is voting fraud. What fraud is going to occur because more people can get out to the polls? I mean, Republicans really have a hard time defending this one. And it's just very unfortunate that we're going to have a decreased participation in our democracy. It makes our country so unique.
Absolutely. And Ian Millhiser over at Think Progress, he's the editor of Think Progress Justice, put together a great list of probably some of the biggest issues that are going to come before the Supreme Court during this term. And I wanted to kind of run through a couple other of those. We've seen this first decision, the Ohio decision. Court is off to a very bad start when it comes to protecting democracy. But there's a lot of other important issues out there. And I think one of them, one of the biggest ones, obviously, is they're handling one very high-profile pregnancy discrimination case. Tell us a little bit about that one.
Yeah, this is a case that will be coming up before the court, and unfortunately the court does not have a particularly strong record on protecting issues involving women and women's rights, and Justice Ginsburg has taken particular note of that she hopes that this so-called blind spot among the court will sort of improve and resolve, and they'll begin to view these issues in a more favorable light. But the facts of this case make it very clear to me that this is a case that should be reversed by the U.S. Supreme Court. We had a lady who was pregnant and worked for UPS and had to pick up, before she was pregnant, had to pick up packages up to 70 pounds. And of course, her medical providers indicated and gave written notice that she should be placed on light duty, and UPS refused to do so. And as others have pointed out, individuals who are not pregnant but perhaps are injured are customarily put on light duty by UPS all the time. So the question is this gender discrimination because she's pregnant and she can't lift 70 pounds? And we have a Pregnancy Discrimination Act on the books, but it has been construed in a very unfortunate way to actually work against pregnant women. Even Republican members of Congress had stated that was not their intent. So very hopeful that the U.S. Supreme Court will properly construe this, but given the history of how they've been coming down against women's rights on this court, it's a concern.
What is amazing about this case, too, this pregnancy discrimination case, is obviously, as you just mentioned, Republicans in Congress have said, whoa, this is not what we meant when we passed this law. But you also have business groups, the U.S. Chamber of Commerce, the U.S. Solicitor General. 23 pro-life Republican organizations have filed amicus briefs in favor of the plaintiff, in favor of Mrs. Young here. And so UPS is on the wrong side of other major right-wing corporations, major right-wing groups of the entire Democratic Party. UPS has no friends in this case at all, because everybody else looking at this, it doesn't matter what party you're affiliated with, you can see you can't do this to a pregnant woman. My wife and I, we just had another child a couple weeks ago, and I couldn't imagine asking my wife when she's 9 months pregnant, or even when she was 6 or even 1 month pregnant, to pick up a 70-pound box. You know that that's physically not a capability and that it could easily harm a fetus. And so this whole case, it's almost ridiculous, but like you pointed out, this court has a very horrible record when it comes to women's rights and gender equality. And so I don't see any surprises happening here. I think we're going to see a 5-4 ruling where the court goes with UPS.
It'll be very unfortunate if that does occur. And as you said, the amicus curiae briefs have been flying into the court on the other side of the issue. And the bottom line is that there still are terrible gender discrimination problems in the workplace, whether it's unequal pay, and here we have just what's a clear-cut case of discrimination based on pregnancy. And so hopefully this will be a good test case to begin to turn the tide around. But a 5-4 decision wouldn't be unexpected on going the other way, I'm afraid, as you say.
And speaking of discrimination, another big issue that's coming up for the court, again, out of the state of Alabama, the state that brought us Shelby v. Holder, we've got Alabama counties trying to racially gerrymander their state. And the Supreme Court is going to hear this case this time. 2 separate cases in Alabama where basically they took supermajorities of African-American citizens, shoved them into these tiny little districts to kind of weed out their vote from other Republican districts. Last year we saw we saw the Voting Rights Act just completely gutted by the Supreme Court. But what's interesting about these 2 new Alabama cases is that they're actually relying on Section 5 to get these racially gerrymandered districts in place. Tell us a little about this. I'm curious about this case to know the legality of it.
Well, yeah, it is a real concern. Obviously, when we talk about the voter suppression issues and trying to keep people away from the polls, and then this is the other big strategy, right? Is packing these districts and basically creating a couple of super majority districts, so to speak. That is districts where you have a huge percentage, in this case, of African American voters, and instead of maybe having twice those number of districts that might have minority representation, frankly, Democratic representation in the House, we have this gerrymandering that's going on in the state legislatures. And this is a part of the overall plan of Karl Rove and the Koch brothers, and it's being rolled out state by state. And so there'll be a very interesting analysis as to whether or not this is appropriate and this legally passes muster, because it has essentially what is a discriminatory effect against the voters and against minority representation. And so coming off the heels of Shelby v. Holder and trashing of the Voting Rights Act, very interesting legal questions here about whether or not the Supreme Court will make a decision that this disparate impact of this racial gerrymandering in the districts in Alabama is consistent enough with the protections under the Voting Rights Act, which basically speaks to whether a particular group has had a disparate impact or an unfair impact, such as keeping minority voters away from the polls. Is this essentially the same thing? So a difficult argument, and we'll have to see where the court comes down. Some are predicting that we may see a reversal down here in Alabama, but given the history on the Voting Rights Act, it's also a real concern. But hopefully the Supremes will see this for what it is, and it's just unfair, and it's creating a Republican majority in these Deep South states.
I think one thing is absolutely clear, not necessarily with the court, but for the state of Alabama. If you are a minority and you live in the state of Alabama, they clearly do not want you to vote. I mean, that's one thing that I think we can all pretty much agree on, just based on what's happening with this racial gerrymandering, the challenging of the Section 5 of the Voting Rights Act. They do not want these people to vote, and that is, again, as we discussed with the Ohio issue, you're excluding people from our American democracy. It's not fair. It's not American.
That's right. And if you are gonna still insist on voting, and which hopefully you will, they're going to pack you into the district and put you in a district with all the other minority areas within the state, so that they can totally minimize your influence and only have one or two minority districts in the whole state. So.
Right. We've only got about a minute or so left, but I did want to hit on one more case that's coming up. It has to do with posting on Facebook and whether or not what you post on Facebook can land you in jail. There was an issue. A young man had written what some had perceived to be hip hop lyrics, but it was kind of graphic, talking about a murder, and he was arrested. He had a couple prior arrests in the past. Had spent 3 years in prison, but I think not necessarily with the case that they have there. I think the bigger implication for this is this going to kind of turn the tables on what people post on social media, making them liable? Can they be fired from their jobs? Can they go to jail? Things like that. Has privacy just been completely eroded here? Give me your take on that.
Well, it is a very interesting freedom of speech issues are raised, and this is a case. If there was a test case for those that want to restrict free speech, this is a very good test case, because the threats which were posted on this Facebook account to this man's wife were, very direct, very, very vile, and so forth. And he sort of tried to cover it under the cloak of First Amendment freedoms, but it was a very personal and direct attack, and one in which the reader, depending on their relationship there, she could have certainly felt threatened reasonably. And so those facts could set it up for a restriction on free speech, which would be unfortunate if we see free speech dialed back in other areas. So I wouldn't be surprised if the court will affirm this ruling that this in fact was threatening speech, and this man is still in jail as I understand it, and would affirm the conviction. The thing is that free speech and other comments online, which certainly don't even reach to that degree, may be impacted by this decision. And if we quell free speech in these other venues, that would be unfortunate. And often certain facts will create law. So bad facts can make bad law, and this may be one of those situations because this man went so far.
As we've written about in the Trial Lawyer magazine, there have been a couple cases of lower courts upholding that what you post on Facebook can indeed get you fired from your job. So, this online world that we live in, social media and things like that, people need to realize that, while we do have free speech, always be careful what you post, because you never know when a right-wing court is going to get a hold of it, and we're going to lose even more of our rights. But David Haynes, unfortunately, we're out of time. We will check back in with you. Obviously, we'll stay on this court and hold them accountable. And thank you so much for everything you do.
Thank you.
U.S. Attorney General Eric Holder announced recently that he would be stepping down as soon as Obama could find a replacement. Holder's tenure as AG has been marred by his refusal to go after the Wall Street banks that crashed our economy before Obama took office. And it was the anger towards these institutions that actually helped to get Obama elected in the first place. Joining me now to talk about Eric Holder's legacy is Michael Burg. So, Michael, over the years, we have talked a lot about Eric Holder and just pretty much the long list of failures that he has behind his name. Now he's come out, he says he's going to resign as soon as Obama can find a replacement. But I think these 6 years of Eric Holder are really, really telling about what's happened in the Obama administration, since he came into office. Eric Holder is the prime example of everything that's been wrong with the Obama administration. And I think it all starts, dates back to the fact that Eric Holder is a corporate attorney. He came from Covington Burling. Lead us in a little bit with some of his background there.
Well, yeah, he was with Covington Burling, which is one of the largest law firms in the world, represents some of the largest corporations of the world, J.P. Morgan Chase, Wells Fargo. They represent Bank of America. They've represented a lot of the players who led to the loss of $7 trillion in the world economy. And so what's really interesting here is, first of all, to have him be in that position under the circumstances that existed when Obama took office, where the crash had already occurred, these clients of his law firm were the people who he was going to have to prosecute. And what's crazy about it is that Covington, they continue to say, we're the law firm of the year, we get the best deals for our clients, and they did. Because as you know, and we know, not one of these perpetrators, and that's what they are, these are perpetrators of the fraud and the $7 trillion loss, not one has been prosecuted criminally, and in my opinion, the Attorney General Holder has intentionally and willfully failed to go after them because of his former firm's interest.
And what's amazing about it is that there is not a lack of evidence here. There are plenty of investigations, the FBI going all the way back to 2004. They came forward to the government, again, this was when Bush was president, but they said there is so much fraud taking place in the mortgage banking industry that we are headed for a crisis that will be worse than the savings and loan scandals of the 1980s. So the FBI had all this information. In 2005, they came out again. They had even more evidence against the criminal activities for these banks. Obviously, Bush, very corporatist. He's not going to do anything about it. We had Alberto Gonzalez and, that whole crowd. Of course, they're not going to prosecute. And when all of this anger hit this fevered pitch in America, we want change. We want accountability. That's what Obama rode into Washington on, this promise of this hope and this change and accountability. I mean, people forget about the accountability part, but that was one of his main promises. And first thing we get is Eric Holder, and he looks at this evidence and says, no, thank you. What was this evidence? What did we know when Eric Holder took office?
Here's what we knew. And I just want to say, our law firm, Burg Simpson, we have probably the first civil case. We filed it in 2008 against the rating agencies, against UBS. That case has been stalled in the courts. We've had judges change. We still don't have a trial date. And let me just say this. We were involved in giving evidence, and then I'll go through the evidence, to not only the FBI, but the SEC, the Senate hearing, Senator Levin's Senate hearings, the House Senate hearings, and all the evidence we gave them. And the evidence that we gave them consisted of collusion between the rating agencies and these large banks with regard to these CDOs and the securitized products. We gave them evidence of secret meetings. We gave them evidence of knowing that they were putting grades of commercial grades of triple B, A, double A, triple A on things they knew were basically worthless. And all this was going on. All the evidence is there. And Attorney General Holder had never once prosecuted criminally any of these actors. We also know that the prosecutions that have been done on behalf of the government. And Covington says, we get the best deal. Well, guess what? The homeowners and the United States of America got the raw deal. And all these things, we expected better from the Obama administration. We expected better from the Attorney General. And we didn't get any of that.
Well, I think it's interesting. Recently, the social media has been buzzing. You get this Real Housewife from New Jersey and her husband. They commit mortgage fraud. They both got a couple years in prison, I think. And these are just
I think he got 3 years.
People.
Right.
And we can prosecute this pseudo celebrity and her husband, but we can't go after someone who's sitting at the top of a company like J.P. Morgan or Bank of America who knows that this fraud is going on. If they don't know what's happening in their own company and they say, I had no idea fraud was going on, then you need to be fired anyway because you're a terrible CEO because you're not paying attention. But we can get these little housewives in prison, and we can't get one of these guys with a mountain of evidence. I mean, somebody would have to be really either just delusional or completely clueless to think that Eric Holder did not direct his Justice Department to not go after these banks. And like you said, it all has to do with the fact that these are his friends. These are actually his clients. He has gone to court for them. And he did it at the Justice Department too.
And I think you make a great point there, Farron, which is, unfortunately, even if we don't get the CEOs, even if we don't get them, we have emails of people who are in the middle management or upper management in which they are directing the fraud, in which they are participating. We have an email which is public, which has been seen, in which while they're selling these CDOs, knowing that the downgrades are coming, knowing that this is going to be worthless, selling it for hundreds of millions of dollars to pension funds, to municipalities, they're calling it crap and vomit while they're selling it internally on their emails. Now, those people should go to jail. Unfortunately, as you point out, we have someone who makes a misrepresentation, these people on this reality show, about their assets, are now going to jail for, I think she got 6 months and he got 3 years. A person whose family is starving, who goes in and steals some clothes from Mady and F or one of the other places, they get prosecuted. They go to jail, and they should. I'm not defending these celebrities or the people who are stealing or holding up a gas station, but we need to have at least equal justice because the hundreds of dollars that are stolen that send people away for 3 or 4 or 5 years, we're talking about trillions of dollars that were stolen from the American people. People lost their homes, the mortgage fraud. And what did this country do? And what did Holder do? And now he's going to waltz away and he's going to end up back at Covington or one of these other big firms defending these same criminals. And that's what's going on in this country.
It is. And Lanny Brewer, who was in charge of the criminal division of the Justice Department, recently left the Justice Department, went back to Covington Burling. He already went back to corporate law.
Right.
And you can, 6 months from now, we'll be sitting here talking about the fact that Eric Holder is once again an attorney at Covington Burling. But real quick, you had mentioned, homeowners are the one who's got the raw deal. These banks stole $7 trillion. What did Holder do? Talk about the fines. Did any of that even matter?
No. In fact, the fines, people don't realize that there's two parts to that. One, we gave these banks billions and billions of dollars to begin with as part of the bailout, which was started by Bush and continued through with the Obama administration. So that's one thing, and maybe that was done to save the economy. But two, that the fines they gave them were so insignificant. $36 billion. They made hundreds of billions of dollars just off the money that the government gave them. This is and none of that money has gone back to consumers. None of the monies have gone back to the homeowners. None of the money has gone back to the people who really have been hit hard, the pensioners, the people who lost their pension as a result of this fraud. And it's time for the populist people, the people who watch this show, to stand up and say, we're not going to allow this to go on. We're going to use it, go and vote against it. We're going to protest it against it. We're going to try to change things, because if we don't do it, these giant corporations and these giant law firms are going to continue to run the United States to the detriment of the American people.
One more point on those fines, too, a lot of people overlook is the fact that we not just through the bailout, but we're still paying part of those fines. We, the taxpayers, because they get the subsidies to basically cover that, and they can write it off. And the other part, and this is, from the Justice Department itself, they said usually when they impose a fine, they're lucky if they get back 25% of that fine. So a bank knows, you know what? I can make $100 billion off this. I can get fined at worst $1 billion, and then at worst, I'll pay 25% of that. That sounds like a great deal because that's going to put money in my pocket. I won't go to jail. We'll pay a small fine, and we'll continue doing it. And that's what they're doing today. This criminal activity has not stopped. I don't even think it's slowed down, and that's, again, mostly because they know they have a friend sitting there in Washington, Eric Holder, who will do nothing about it. And Michael, thank God we have people like you and Mike Papantonio and all of the other folks that we have on this show who are out there, who are fighting, and they're getting homeowners the relief that they deserve. Michael, thank you so much for being with us today.
Well, thank you, Farron. Appreciate it.
For decades, doctors have been receiving all sorts of perks from pharmaceutical companies. Paid speaking gigs, golf junkets, food, vacations, the list goes on. And in return, drug companies are rewarded with more prescriptions for drugs that Americans, most of the time, really don't need. But those days could be coming to an end thanks to an overlooked provision of the Affordable Care Act, and I have Howard Nations with me now to tell us about it. Howard, I have to admit, from the start, I've been a very vocal critic of Obamacare. My issue with it is obviously it does not go far enough. It does not do anything to, help with pharmaceutical price negotiation. But a couple weeks ago, the story came out, something I had no idea about, that there was a provision within Obamacare that makes doctors have to disclose how much money they're receiving from Big Pharma. Tell us a little bit about that.
Well, Obamacare requires those disclosures, and what they show is what we've known all along, is that there's a substantial connection between the medical business, the healthcare providers, specifically the doctors, and the pharmaceutical companies and the device manufacturers. We know it in the past from whistleblowers who came forward and told us about payments that were being made to doctors. We know it from drug lawsuit settlements, major settlements, where they made it a provision of the settlement that the pharmaceutical company had to reveal payments that they were making to doctors. And we know that from the whistleblowers that a lot of civil and criminal penalties have been imposed because of the kickbacks and the junkets to doctors to influence them to prescribe off-label, to prescribe expensive brands instead of generics, and even to conduct phony studies for the FDA to get approval. So this is really nothing new to pharma plaintiffs' lawyers, because we sue for death and injury for tens of thousands of patients. We discover off-label use all the time. We discover phony clinical studies. We see knowing promotion of defective products and dangerous drugs, and we see doctors in total complicity with this.
And so you obviously as a trial lawyer, you've taken on the pharmaceutical companies. So you've seen the documents. You go through and you know that this happens. You've known it for a very long time. And now what's so great about this, piece of Obamacare is that the average person, maybe they've been going to their family doctor for 20 or 30 years, they can now see, is this guy on the take? Has Big Pharma been taking him out to dinner every week, or has he gone on, vacations, on their dime? And that is very, very important, as you point out, because a lot of times we do have these, pharmaceutical sales reps, the pharmaceutical companies encouraging doctors to promote off-label use, and that's where a lot of trouble comes in. But, give us a little bit more on why this is such a problem. Why do we need to know this?
Well, first of all, this is a multi-billion-dollar industry. And thanks to whistleblowers and thanks to the lawyers who bring these lawsuits against the pharmaceutical companies, we know about all the civil and criminal fraud that's taking place. And what happens when you see a $3 billion fine against GlaxoSmithKline, such as occurred in July of 2012, for misbranding Paxil so they could sell it to people under 18 years of age, that came about as a result of the Justice Department taking information that came from whistleblowers and from the work of the plaintiff's lawyers in prosecuting the original cases. We do all the work. When it's all over, the Justice Department comes along and says, okay, fine, that looks good. They take our information and then they use it to impose these large fines. But to give you some idea how big a problem it is, in addition to GlaxoSmithKline's $3 billion penalty, in September 2009, Pfizer paid a $2.3 billion fine for fraudulent promotion, and these are civil and criminal fines. And in November 2013, Johnson & Johnson paid $2.2 billion for kickbacks to doctors and to pharmacies and to doctors for promoting off-label use. And just so we can understand what off-label use is, the FDA approves the drug for a very specific use. The companies are prohibited by law. It is illegal for them to promote that drug for any other use other than what was approved by the FDA. But doctors, for whatever reason, doctors can prescribe that same drug for any use they want to, despite the fact that it hasn't been approved by the FDA for that use. So the doctors alone can increase by billions of dollars, literally, increase by billions of dollars the sales by the drug company by simply prescribing it to teenagers, to children, for whole different uses other than for what it was approved. So the result is that the pharmaceutical companies spend millions of dollars to influence the doctors to do exactly that.
So, and I guess this is just kind of an extreme, scenario, but basically you could go into your doctor and say, look, I'm having these really horrible migraines. And the doctor says, oh, you know what? Let me give you some Zoloft for that. Now, I know it's an antidepressant, but trust me, it's going to treat your migraine as well. And that's, a situation, maybe not that extreme, but that is what's happening. It's been happening for a very long time. And now we can find out, is he doing this because Big Pharma, just paid for him to go to the Caribbean for 2 weeks? And but it's also, it's not just that. It's not just, flat out gifts. There's other things. I know ProPublica has done a fantastic job of laying out things like speaking fees that these doctors are getting. Tell us about some of those.
There's a great article this past week in the New York Times on this, that during a 5-month period, from August to December 2013, the drug and device companies paid doctors $380 million during a 5-month period just for speaking and consulting fees. Some of the doctors got $500,000 each. That's $100,000 per month during that time frame. It must be a hell of a speech. That's all I can say. And also between August and December of 2013, the drug companies paid 4.4 million payments to more than 500,000 healthcare providers and hospitals, totaling $3.5 billion. That's to say that this is not an isolated case. They made those payments to 500,000 healthcare providers in that 5-month period. And the Times also shows their own and other studies show that doctors involved with drugs and devices with that industry are more likely to prescribe drugs, the more expensive drugs, and potentially inappropriate drugs than normal doctors, than those who are not associated in that fashion.
So it does, Big Pharma is winning with their strategy. They know I can pay, this little local doctor or maybe a hospital doctor, come to our conference, give them $100,000 to speak for 30 minutes just to tell this group of people that, hey, a drug like Paxil works really well. It's a great drug. Great drug. Give me my $100,000. And it's really, that seems to oversimplify it, but it really is that simple. And there are times as well where the drug company itself will ghostwrite a paper, the doctor will stick his name on it, and they'll send it out to medical journals, and it's just the company doing these fluff pieces, these advertorials, if you will, about how great their drugs are, and they get credibility by having a well-respected doctor put his name on it. And I know you've seen this in the past. It's just, it is amazing when you start to look at this and realize that this has been happening and we didn't know.
Well, it's not just the drug companies, it's also the medical device manufacturers. And they work heavily, a lot of times, with royalties. In that same report from the New York Times, they said that in a 5-month period, there's a San Antonio orthopedic who received in excess of $7 million in royalties over a 5-month period in royalties, travel expenses, and speaking engagements from Arthrex for promoting their orthopedic surgery devices. And there's currently a case that's in litigation of a California doctor who received in excess of $8 million in royalties and travel and speaking fees for traveling around and promoting the Pew ASR hip implants. The problem was that the product was defective. Thousands of plaintiffs were injured and had to have hip replacements as a result of it. The product was taken off the market. There's now, as a result of discovery by plaintiffs' attorneys, there's now been a major settlement. But that's the kind of thing that you see on a regular basis in the device side of this scheme.
And, you just brought up a great point. It's mostly the result of the actions of plaintiffs' attorneys like yourself. And now we are seeing some pushback against these big pharma bribes from within the medical community, aren't we?
Yes, and it's from a very interesting source. It's the Medical Students Association. And the medical students said, we're not going to put up with this whole idea of it's a conflict of interest. How many times do you have to be told this? A Harvard medical student who's a spokesman for the group of the American Medical Students Association said, quote, "We don't want doctors to receive what are effectively bribes from companies." And the result of that movement has been that some of the academic medical centers and the medical schools have established conflict of interest rules. But the fact of the matter is, there are just so many billions of dollars involved in these sales and so many billions and billions of dollars in profits to these pharmaceutical and device manufacturers, it will never stop. They just figure the price of that $4 billion fine. If we get caught, we're going to have to pay $2 billion to settle the cases with the plaintiffs. We're going to have to pay $2 billion to the government. So they just add that into the price of the product and roll right along and keep making billions of dollars. So I don't see any help on the horizon.
Well, one of the bright spots here is that we do have people like you and Mike Papantonio out there fighting this every day, holding Big Pharma accountable, holding doctors accountable, and protecting consumers who have no idea that this is happening. And Howard, we always appreciate everything you do, and thank you for being with us today.
My pleasure, Farron. Thank you.
Earlier this week, Ring of Fire's Mike Papantonio and Sam Cedar sat down to have their weekly discussion of the news that the corporate media overlooked from the past week. Let's take a look at what they had to talk about.
So, Pap, quite a week in news, and in particular, there was a couple of stories that are really important that involve the midterm elections and, frankly, elections going forward. More on this war on voting that the conservatives have been waging now for years, of course, but particularly from a legal standpoint over the past 3 or 4.
Well, yeah, I mean, you can't look at the Ohio ruling that came out of the U.S. Supreme Court as if it's only about Ohio. It's not. This Ohio ruling has impact on every state in the union where an appellate court that has some brains has invalidated voter suppression laws. Okay, so let's begin there. First of all, it's not just about Ohio. Next, it's really about the Supreme Court. Look, this is a court that's become just an extension of regressive, punitive Republican policy. They've been intent on keeping minorities and students, keeping the elderly and disabled away from the polls, because historically that's a group of people that always votes against Republicans because they think that they have gone completely dingbat. As you might imagine, if you're a woman, yeah, every week it's another thing that the Republicans are trying to do to you. If you're a minority, it's the same thing. If you're a student. So, of course, this is a group that they don't vote for Republicans most of the time. There was no question in my mind or anybody following this court, Sam, that this is how they were going to rule. I could have told you as soon as I saw it go to this court, as soon as I saw what the issue was going to be, that what their action was going to be. Could have told you immediately. Interesting that they did it with 16 hours before voting was supposed to start, but that's typical of this corporate-controlled majority, Republican-controlled majority. They become almost comical in their predictability, and that's a problem. The intent and political motivation of this court was made very clear in this Ohio voting case. This predictable majority has deprived thousands of Ohio residents the right to vote early. Simply put, they've kept minorities, students, elderly, away from the polls, disabled, away from the polls. The court clearly understood that for many years, for example, workers who want to vote, that their only chance to cast a ballot was on this special period that Ohio set aside called the Golden Week. Mm-hmm. And that's where voters could register and they could vote on the same day. Makes perfect sense, doesn't it? I mean, anybody says the more people that go out and vote, the better democracy works. Well, that's just the opposite of what Republicans want. As a matter of fact, the court clearly knew, this Supreme Court majority, the Roberts majority, they completely knew that Ohio Secretary of State John Husted all but admitted that voter suppression efforts that were taking place in Ohio, these laws that we're talking about, that they were there to keep minorities from voting. He's clear about it. This is the Secretary of State, Sam,
right,
for the state of Ohio. He was clear. He was unequivocal that was the intent of the law. And the sad part is that this Supreme Court knew that. It was before him. It had been said. They admitted that this was to keep minorities from voting. Nevertheless, they do exactly what's predictable about this absolutely dysfunctional banana republic, third world majority of Alito, Scalia, Thomas, Kennedy,
and Roberts.
And Roberts, yeah, you got it.
And we should remind people that same those five justices struck down Section 4 of the Voting Rights Act last year. And in doing so, they literally went against the reauthorization of the Voting Rights Act that took place just less than 10 years ago by both Republicans and Democrats. They overruled essentially that reauthorization, saying that politicians didn't have the political courage to essentially disenfranchise black voters. I mean, that's fundamentally what they're saying. And by gutting the Section 4, in fact, when they gutted Section 4, which, as you know, Pap, placed about a half a dozen or so states, a bunch of counties across the country, they were in a special, essentially, group that because of their past racist behavior in disenfranchising minority groups from voting, they had to get pre-clearance from the Department of Justice. And the moment that essentially the Supreme Court struck down Section 4, they invited Congress to come up with a new mechanism rather than just historical racism to require pre-clearance. But of course, Congress is not about to do that. What they did is they basically opened the door for states like North Carolina, which within days after that ruling started to create, and I should say Ohio and other states started to basically impose these restrictions on people's right to vote.
Yeah.
So and then when it shows up at the Supreme Court, of course the Supreme Court is going to let that stand.
Sam, this is a story to me about the Supreme Court. It's about Ohio, and it's about that the rest of the nation is going to suffer by not being able to vote.
And it's not on the grounds of anything other than this is just what the Secretary of State of Ohio wanted.
Well, he admitted this is what he wanted. Look, this is the white Republican elephant sitting in the living room that the media is so damned afraid to talk about it. But you and I need to talk about it. What we have on this court is we have politicians, thuggish politicians, by the way. This majority is a collection of thuggish politicians dressed up in black robes. And they're the highest court in the land. They're there for life, virtually impossible to impeach them. They're there forever, and we have to take it. you see. We have to take it. So it's important that we understand who these thugs, Republican thugs, protecting other Republican thugs, it's important that we understand who they are. I was with a group of some of the best constitutional lawyers in the country recently, Sam, and to a person, there was this solid agreement that this Supreme Court majority has become this freakish character of the highest courts in what you might see in emerging third world countries. Everybody in the room characterized that one way or another, either the Banana Republic type court, third world emerging country, third court. Everybody had the same image. One litmus test for judging the dysfunctionality, for example, of a final appeals court is the quality of predictability that they show in their policy decisions. In other words, do you just simply have to look at the politics of the party, Republican in this situation? The Republicans want to stop voting, so we know the Republican majority is going to vote that way. Right. If they want to do something environmentally, we know the position on fracking, the position on drilling. The Republican majority of this court is going to vote that way. So this predictability is one way we look at, has our court fallen into this image of third world? For example, a final appellate court in a third world country that's situated in a setting of, let's say, corporate or military domination, well, they're predictably going to rule always against the average citizen and in favor of the industrialists who represent the money behind the government. That's called fascism. They'll predictably rule against environmental protections in favor of lawless polluters in third world type courts. This is one of them. And interestingly, those same third world style courts will every now and then, and you and I have talked about this, every now and then, Sam, they'll throw out a few bones of appeasement on social issues. Maybe it'll be gender rights. Maybe it'll be reproductive health rights. Maybe it'll be prisoner rights. So what we have in America today is a Supreme Court majority that has morphed the court into this clear blueprint of the vast majority of third world courts of final appeal. Their ultimate appellate courts, like we might find in places like South America, maybe Africa, Middle East or Asia. In fact, the chief judge of the court, Sam, and we talked about this, I think you and I had this conversation, about the Chief Judge Roberts several weeks ago pondering the question about how the public image of his Supreme Court majority is dramatically suffering, as if he doesn't understand that the answer is right in front of his nose. I mean, right. If it wasn't so tragic, it would be a Keystone Cops laughability kind of scenario.
Right, and they're just going to keep rolling on. Earlier this week in North Carolina, an appeals court ruled of the Fourth Circuit ruled that the new or at least two of the North Carolina's new voting restriction laws need to be essentially enjoined from being implemented. That would be the notion of an ID and the idea that your vote doesn't count, even if you vote for the right candidates, if you somehow go to the wrong polling place. And that's important, of course, because we know over the past 2 weeks that the AFP, Americans for Prosperity, sent out literally hundreds of thousands of official-looking voting guides telling people to go to the wrong polling places, telling people that the date of registration was later than it was. And this was a way of suppressing voting, and it was a 1-2 punch, right? The legislature had made it such a way that if you had followed this voting guide and followed their directions, you would have disqualified yourself from voting. So the appellate court overruled that this week. If some North Carolina minority voters are going to be disproportionately adversely affected in the upcoming elections, it was important to enjoin these new laws from taking place. And the Supreme Court doesn't seem to think that that's an issue. In fact, on the contrary, of course, it's even saying that's naive. The bottom line is they're with that program. That's what they want to do.
Look, they're waiting to review. They want to review North Carolina so they can do the same thing they did to Ohio, talking about the U.S. Supreme Court. They want to review Wisconsin the same way so they can do the same thing to Wisconsin that they did to Ohio. Look, anytime a room full of constitutional lawyers can predict what a court majority is going to rule within 100% accuracy, that's a symptom of failure of the court. I'll make predictions. They'll continue to narrow voter access 100% of the time. They'll continue to expand personhood of corporations 100% of the time. They'll continue to expand the rights of corporations to commit fraud against consumers, to escape criminal sentencing when they've committed crimes 100% of the time. They'll continue to narrow the rights of consumers, access to the court, and expand things like arbitration 100% of the time. They'll continue to rule against Americans where it comes to environmental protection. They'll vote for the expansion of rights in gender disputes of a small collection or maybe a small collection of other small social issues, but they're always, as long as it doesn't interfere with the corporate bottom line.
So, Pap, this week there has been a number of huge blockbuster stories that have come out of the Washington Post talking about what appears to be a complete breakdown at the Secret Service in terms of protecting the president and the first family. I mean, it came out this week in dribs and drabs. There is clearly, and it's basically one reporter from the Washington Post who must have a very high place sourced at the Secret Service when you see the nature of these stories and the knowledge of these disparate stories. We've got really 3 or 4 different stories that are gone on that show the failure of the Secret Service. Last week there was a man who jumped a fence in front of the White House. He ran up, and at the time, we were told by the Secret Service that he made it basically to the front door of the White House, and everyone was rather shocked about that. Well, it turns out later, about a week later, we realize, and it's reported by the Washington Post, that this man not only made it to the front door, he entered the front door. He made it through the lobby of the White House. He made it through 1 or 2 other rooms and actually was able to run around inside the White House to another end of the house.
Breakfast. He made, bacon and eggs. Go ahead.
The man's holding a knife.
Yeah.
He ran right by the staircase that could have led him up into the private residences of the president and his children. And then we find out that, in fact, he was ultimately stopped not by an on-duty Secret Service man, but an off-duty Secret Service man who just happened to be there. And then we find out that this is a guy who had been stopped by Virginia State Police a couple of months earlier. He had virtually an arsenal in his car. He also had a map of Washington, D.C. and a line to the White House. The state police informed Secret Service. They never followed up on it. The guy shows up a couple of months later in front of the White House in his car with hatchets in his car. The Secret Service is still not surveilling this guy. And this is an unbelievable breach of protocol. It turns out that the alarm, the emergency alarm that should have indicated someone just came through the door of the White House unannounced was muted. This is a massive breakdown. It was also revealed this week that in 2011, a shooter with a rifle from 700 yards away or more from the White House put 7 bullets into the side of the White House. The Secret Service was told to stand down at that time because there was a report that it was just the backfiring of a car. The Secret Service didn't. Well, they only found these bullet holes. Exactly, because a maid found rubble and glass shards on the ground 4 days later. There was a report this week that a contractor with a criminal record and carrying a weapon was allowed in an elevator with the president in Atlanta when the president was going to the CDC, the Center for Disease Control, to talk about steps to contain Ebola overseas. I mean, this is a stunning breakdown.
You know how I see this, Sam? If this went on in any other business, matter of fact, Ed Schultz had a great angle on this, I think. He said, look, they'd all be fired. You fire them. You start again. If the people in charge can't run it, get rid of them. This is only a one-shot deal, so to speak. No pun intended. You only get one chance at something this important. And if it doesn't go, you fire them. You get rid of them. You get competent people in there. And when I hear the testimony before Congress, I go, it's almost like every word coming out of their mouth. How about the setup? How about in Congress they're saying, now, has this happened? How many times has this happened? Oh, well, we don't think there's ever been a problem. Just one other time, 20. Well, no. Then it's disclosed, well, what about the guy in the elevator with the criminal record and the gun? What about that guy? Oh, you mean that guy. They are a bunch of incompetent boobs that we have glorified in this mystical aura of, oh, my God, they're the Secret Service, their best training in the way. They made movies about them, and you think, oh, these guys are just superstars. Well, they're not. They may be superstars on the ground, but you have to have leadership. Look, there shouldn't be any question. They should wipe out all of the leadership here and start again. This to me is not complicated. It's not complicated at all. You just start from ground zero, and you get rid of everybody having anything to do with any part of any one of those stories. Get rid of them, purge them, start again.
You can catch even more news that the corporate media won't report on our website at ringofireradio.com. And that's it for this week's Ring of Fire, but you can keep up with us throughout the week on our website at ringofireradio.com, on Twitter at Ring of Fire Radio, and on Facebook. I'm Farron Cousins, and we'll see you next week right here on Ring of Fire.